Hello, my name is Ashley, Client Services Coordinator with Russo Law Group. Thank you all for being here on this very breezy Tuesday, April the 21st. Today we are hosting a presentation on COVID-19, how trusts can protect me and my family. I'm joined by our esteemed presenter, Vincent J. Russo, Managing Partner of Russo Law Group. We are known for being Long Island's signature elder law, special needs, and estate planning law firm with 5 offices on Long Island and New York City. Recognized by the U.S. News as a best law firm in the area of elder law, we've had the privilege of helping over 17,000 families. Vincent has championed the rights of seniors and people with special needs since 1985 and is notably one of the most prominent attorneys in his field. Among his many other awards and distinctions, he's also recognized by super lawyers as a top 100 lawyer in New York. Now, before I pass it over to Mr. Russo, a quick housekeeping item regarding questions. Please send us your questions as you have them, but be sure to include your email address. We will do our very best to address everyone in real time, but if for some reason we can't, we will follow up after the program. All right, and with that, I'll hand it over to Vincent to take it from here.
Thank you, Ashley. It's windy and it is pouring rain right now on Long Island. So today we're going to tackle this topic, how trust can protect me and my family during this crisis period. Today, what I'll focus in on is how a trust can help me, which is the right type of trust, and then what steps should I take once I understand the first two. So let's jump right into the topic today. And I hear from clients all the time that there are 4 major concerns. And in light of the emergency period we're in, now that's even been heightened. First, avoiding probate. Someone passes away and a will has to be probated in court. 2, protecting my assets, especially if I need long-term care or if I fall into debt. 3, protecting a loved one. And 4, saving taxes. Today, we're going to focus in on the first 2, avoiding probate and protecting assets. Let's start with what probate is and why do we want to avoid it. Your will is not valid unless it is probated in court. So a will becomes valid and effective when a filing is made in the surrogate's court here in New York and a judge says, yes, this will is valid, it was properly executed, and appoints an executor. So that can create delays. And especially with the court systems down at this time, it could be months before a will is probated. And that will result in delays in the beneficiaries accessing their inheritance. Now, you may say, well, all right, if they have to wait a few months, what's the big deal? But it may be a situation where the family, the surviving spouse and children need access to the assets of, unfortunately, a deceased loved one. The probate process is also a public proceeding, so others can have access to what you did, how you left your assets, who you appointed. There are costs involved, attorney's fees, court filing fees, and if a bond is required of the executor, bond fees. Also, when a will is submitted to court, it makes it easier for someone to contest what you've done. And if they make a will contest, life gets a whole lot more complicated in the estate administration process, and fees could skyrocket. I mean, we've had cases where a will contest has led to over $100,000 in legal fees, fighting and going back and forth between family members as to what they thought mom or dad wanted and how they should inherit. And that, of course, creates further delays. Now, if a will is properly drafted, if it meets with one's desires, if it's signed with proper formalities, then a will should not be contested. And if it is, it has to be contested on the basis of lack of capacity to sign a will or undue influence. In our office, we take steps if there are any concerns that a family member might challenge a will to ensure that everything is done in the proper way. So if there's ever a challenge, then that challenger is going to lose, and it's going to cost them money because they had to hire a lawyer to challenge. So how do I avoid probate? A revocable living trust, sometimes referred to as an RLT. This is a document which is an agreement between you setting up the trust and the trustee. And you could also be the initial trustee. And that agreement, in effect, talks about how your assets will be handled during your lifetime and then after you pass. So it, in effect, operates like a will, but without having to submit the revocable living trust to court. Now, some individuals say, well, that's complicated. Can't I make it easier? I'll just make all my accounts joint with one of my children, or I'll designate a beneficiary. And if life is simple and it's easy and it's relatively straightforward, yeah, that in a perfect world, that could be done. But we don't live in a perfect world. And so naming one child a joint owner, what about the other two children who wanted to inherit as well, that you wanted to inherit as well? Are we going to trust the one child to do the right thing? And then there may be tax consequences to what goes on there. Or you may have a family member that you're concerned about and how you want to leave the assets, you may want to leave it in a more protective way. So revocable living trust can provide for all those benefits, and we're going to get into it. So how does a RLT work? As I said, you're the person setting it up, referred to as the settlor or the grantor, and you name a trustee. You can be the initial trustee. So you're basically in control. You sign a trust agreement, and then you transfer your assets into the trust. If you have a house, you change the deed. If you have a brokerage account, you retitle the brokerage account. While you're alive, you have the right to revoke or amend the trust at any time. You receive the income if you want to take it out of the trust and do whatever you want with it. You have access to the principal, the assets themselves. You control who the trustee is, not only initially you being the trustee, but you name who succeeds you when you step down. You manage those assets during your lifetime, and you control how those assets are transferred from the trust to your beneficiaries when you pass away. Now, from a tax standpoint, you're still the owner. You can use your Social Security number as the tax ID of the trust, and you report the trust income on your personal income tax return. And no gift tax return is required. So in effect, you still have total control over your assets while you're alive, and you control who will inherit your assets when you pass away and who will step in as the trustee. So why does a revocable living trust make sense? Well, it makes sense if you want your family to have quick access to assets. As I said, there's no probate process. Also, you save legal fees and court costs associated with the probate process. So that's a plus. We can minimize paying lawyers, minimizing court fees or a bond fee. That's great. Now, some of our clients own real estate in multiple states. They may have a home in New York, but they have a vacation home in Florida or in Arizona. And in that situation, you actually have two probates. You not only have to probate in New York, but you also have to do a probate proceeding in the state, the other state that has your real property. Now we are doubling up on fees and potential further delays. So anyone who has property in multiple states, an RLT, a revocable living trust, makes a lot of sense. And then lastly, if I have a family member who I think may challenge my estate plan, having a revocable living trust makes it so much more difficult. Not only because there's no forum, the surrogate's court, for them to step into, because your executor had to have a proceeding in that court, giving an opportunity for the beneficiary to challenge. In a revocable living trust situation, the beneficiary, the unhappy family member, has to start their own litigation. They have to go into court and be proactive in making a challenge. And then we think about what that challenge could be. You lack capacity, but you set up a trust and managed it for years. You didn't lack capacity. Undue influence, but this trust was around for years. How could that be undue influence? So very tough to challenge a revocable living trust. Now, can a revocable living trust protect my assets? Well, here we get into the right type of trust. There are so many different types of trusts. We just talked about how the revocable living trust avoids probate, makes it easy for family to access assets when you pass away. If we're talking about long-term care, and we're going to move to how do we pay for that care, and let's say you don't have long-term care insurance, or you don't want to be impoverished, then you have to look at the Medicaid program. And the Medicaid program is an entitlement program, meaning there's financial eligibility rules. So if I want to protect my assets, if in the future I need long-term care, then I would need to set up what's called a Medicaid Asset Protection Trust. That's different than a revocable living trust. And a Medicaid Asset Protection Trust can be funded with my personal residence or some or all of my liquid assets. And I would then immediately qualify for Medicaid home care under the current rules. Now that's going to change in October, and I'm going to be talking more about it over the next few months. But right now, you could transfer that residence into a Medicaid Asset Protection Trust, and you should be okay immediately accessing Medicaid home care. Also, when you put your assets in a Medicaid Asset Protection Trust, once you get past what's called a 5-year look-back rule, then nursing home care would be available under Medicaid. And nursing homes are costing, on average, $12,000 to $16,000 a month. So that becomes critical. So not only are you protecting those assets immediately if you need Medicaid home care, you also have a longer-term plan to protect those assets if you need to go into a nursing home. The Medicaid Asset Protection Trust. So let's go through the protection here one more time. The Medicaid Asset Protection Trust allows you to protect assets from Medicaid in the nursing home. You could keep your income if you want, and you would report that income on your personal income tax return. As I mentioned, it can protect your home and protect your other assets, not only for you, but then leaving it in a protective way for your heirs, your beneficiaries. If you sell the house during your lifetime, you also can take advantage of the capital gain exclusion provisions and save capital gains taxes if sold during your lifetime. You don't lose that exemption. You also keep your senior exemption if you qualify for that. And the added bonus, you avoid probate. So like a revocable living trust, a Medicaid Asset Protection Trust would avoid probate on the assets that you put into that trust. This is the most powerful tool we have in our toolkit when it comes to protecting assets and accessing Medicaid. Now, what happens if you were concerned about falling into debt Everybody's concerned about how they're going to make ends meet while we're in this crisis. What happens if I can't pay my mortgage? What happens if I can't pay my ongoing living expenses? Some of our clients are unfortunately on unemployment right now. Many of our clients are living on a fixed income with their Social Security check. So if things get rough and you fall into debt, well, first, I would say you always have the opportunity to negotiate with a creditor and work out a payment plan. And that would be a good first step if you fall into that situation. But if you're thinking about, well, could I do things now while I don't have a creditor problem that just in case in the future I do, I would protect my assets or some of my assets? And the answer is yes. Here you can do asset protection planning. And there are different ways to approach it. One is to use limited liability companies. So for example, if I own a rental property, every rental property, in my opinion, should be placed into a limited liability company. So if a claim is made against that rental property, it would be limited only to that rental property, and the creditor would not be able to go after your personal assets. Irrevocable trusts can protect assets as well. That could be set up under New York law, or actually, if you set it up under the laws of a different state, there are some states that have highly protective provisions in state law that would allow you not only to be a co-trustee and manage the assets, but also protect those assets if you should fall into debt. Also, if you're running a small business or you're out of business right now as a small business owner, or you're an independent contractor, hopefully you filed for a loan from the Paycheck Protection Program. And a portion or all of that loan could be forgiven if you spend it in a certain way. So looking at government assistance could be helpful. Having a credit line could be helpful if you're in that situation. I did a separate Facebook Live event totally on the Paycheck Protection Program that you can check out if that's of interest to you. So different types of trusts: the Revocable Living Trust, avoiding probate, making it easier for your family, saving fees. The Medicaid Asset Protection Trust protects you if you need long-term care. And an Asset Protection Irrevocable Trust, or the use of LLCs, limited liability companies, can be helpful. Now, I did get a question recently about retirement accounts. Can I protect those? Well, the good news is you don't really need to take any further steps. If you're the account owner, your IRA or 401k plan or 403b plan, those assets are protected under federal and state law. So you're okay. If you inherit an IRA, then you don't have that creditor protection and other steps would need to be taken. Now, let's say you're concerned about your family. And if you leave assets to family members, that could be a problem because you have a concern that maybe a family member already has creditor claims, or they're not financially astute, or they're a spendthrift, or perhaps they're in a bad marriage situation. And the last thing you want to do is leave assets to a child who later is then sued by the husband or wife, the bad spouse, the ill spouse, the devil, and you don't want them getting at your assets that you're leaving for your daughter or son. What about your concern about undue influences? That if a child inherited assets, then people will come out of the woodwork and take advantage, scam them, or maybe they'll invest in a business that'll go out of business soon thereafter. That's a different type of trust that we can use to protect your family. And that's a family protection trust. So here again, different trusts can do different things. Also, we can have trusts to save estate taxes. Now, the good news is that if you have less than $5,850,000, there are no federal or New York State estate taxes. A New York State estate tax will kick in over that amount, and basically at a 16% tax rate. Now, if you happen to have a little, I'm going to round numbers off, over 6.1 million, actually in New York, you'll be taxed on the very first dollar. They take the exemption away from you. And then if your assets exceeded 11,580,000, the tax rate is at 40% at the federal level, plus you have the New York tax. So this is a whole nother subject that we'll do another Facebook Live event on. But there are different types of trusts that you could set up today and take advantage of. You can have an annual gifting trust, a grant or retained annuity trust, a qualified personal residence trust. There are irrevocable insurance trusts that maximize any insurance that you own. You can even set up charitable trusts that save estate taxes. And if you're married, there are marital and credit shelter trusts that can be set up under your revocable living trust or under a will. So lots of options. The key here is if you're over these levels, then you got to see a professional and make sure you implement a plan to save the estate taxes. Now that federal exemption is only temporary at the moment. Congress has to restate it or reaffirm it when we get out a few years from now. So it's really important that you not only look at today and where the tax laws are, but think about the future and what those taxes might become, both in terms of your estate growing in size over time and what the tax laws might be. A whole nother subject. So before I get to just kind of give you a summary, I did get a question here on what's the difference between a revocable trust and an irrevocable trust. Thanks, Jared, for asking. A revocable trust, which you set up, you can change anytime you want during your lifetime. As long as you have capacity, you could revoke it, you can amend it, you can change who the trustees are, you can change who the beneficiaries are. You have total control. In an irrevocable trust setting, it gets a little more complicated. You don't have the automatic right to change the trust. You don't have the right to revoke it, for example. So in order to get the asset protection in terms of Medicaid or saving taxes or protecting family members, an irrevocable trust then becomes critical because it allows us to lock in the provisions of that trust, and it will allow for saving taxes. It'll allow for creditor protection. It'll further protect family members after your demise. Now, that could be scary. Some people may say, well, whoa, I like the revocable trust, but I don't like the irrevocable trust. So here's where the lawyers get involved. And we have lots of ways to fix that irrevocable trust when we draft it so that you actually have more control over it. So for example, with the Medicaid Asset Protection Trust, if you set it up, that's an irrevocable trust. But we give you, the person setting up, the right to live in your house the rest of your lifetime, and no one can throw you out. You get all the benefits of home ownership. We can give you the right to change the trustees. So if you don't like what your trustee is doing, you can put someone else in. And 3, we give you the right to change who the ultimate beneficiaries are. So it's a very clever way of providing all the flexibility in a Medicaid Asset Protection Trust as if it was revocable, but under the Medicaid rules, it allows you to protect those assets. Now, I'll also say with irrevocable trusts, and we'll talk New York law at the moment, there are other ways you can actually change an irrevocable trust, and this is by law. So I'm not making this stuff up, even though it might sound like a little crazy. So an irrevocable trust can be amended if the participants involved get in a room and sign a document saying they all agree to do it. So if we had the trustees and the person setting it up, and we had all adult beneficiaries named in the document, then we can amend that trust under New York law. Also, we have what's called a decanting statute. Now, we think of decanting when we think of taking wine out of a bottle and putting it into another vessel, right? And then we let the wine breathe. Well, with decanting, you can actually, if you got to follow the qualifications, you could set up a new trust and decant the old trust, take the assets out of the old trust and put it into the new trust, and you can have new trust provisions. So there is flexibility there. You got to meet certain requirements, but it can be done. All right. So now let's summarize these different types of trust. Today, we focused on the first two types of trust. One, the revocable living trust, which is a solution to avoiding probate, making it easier for your family, reducing potential legal fees and court costs. Two, the Medicaid Asset Protection Trust, which is a solution to protecting your assets so you can access Medicaid home care immediately, or it's a plan to protect your assets if you needed nursing home care in the future. We also discussed briefly two other types of trusts. We'll do other Facebook Live events when the time comes. One is the Family Protection Trust, which ensures assets pass the family in the most protective way, and the use of irrevocable trusts that will save estate taxes. So now, giving you a lot of information, the question becomes, what do I do? Well, the key is to create a plan. No plan is also a plan, but it's likely going to be a bad plan. So create a plan. Well, you might say, I need help creating a plan. Well, that's where you retain the services of a professional. At our law firm, day in and day out, we're listening to our clients, listening to their concerns, understanding what they own, who their family members are, and what their desires are in terms of how they protect their assets for themselves and how they protect those assets for their family. We can help you. And then the last piece is you got to move into action. You can create a plan, you could speak with a professional, but then you've got to implement the plan. And we will move as quickly as you want. Even during this crisis, there are ways, because of the governors implemented some emergency orders, where we can actually do remote document signing with witnesses and a notary. So we're available by phone, email. You can contact us through the website. So questions and answers. Well, here's, I guess I get the questions and hopefully can give you the answer. We got another question that just came in from Constance. What is happening in October? Constance, bad news, bad news. In this budget bill in New York, just signed into law, the governor, along with the legislator, have passed changes in the Medicaid home care rules. So up until October 1st, seniors, people with disabilities, they want to live at home, they can't afford to pay for home care aides, they need that money to live on, they would come to us and we would say, you know what, we can help you. We may have to take some steps to move assets out of your name. We might use the Medicaid Asset Protection Trust, works really well. We may have to shift some assets over to some family members. And then the following month, we file a Medicaid application. And you're Medicaid eligible. And the local Medicaid office does not hold it against you that in April, you had a $500,000 home and a $250,000 in liquid assets. In May, you could be Medicaid eligible. And right now, there's actually some emergency measures taken by the Department of Social Services all over New York, or HRA in New York City. And that emergency measure that's been taken has provided that if you file an application, you can certify you're eligible. And if you don't have all the documents that we typically ask for, we're going to approve your Medicaid application. And we'll get those documents later on. So we actually think people actually can be approved for Medicaid sooner than what would be typical. Now, when we get to October, that was your question. The law will change. There will be a 30-month look-back rule where when the application is filed, they will look back 30 months. And if you gave assets away without full consideration, or you transferred them to who is referred to as an exempt person or an exempt type trust, then those transfers, those gifts are going to be counted against you. And you're going to be denied Medicaid for a certain number of months, basically up to 30 months, depending on how much you transferred. So that's a serious problem. Now, anyone thinking about whether they might need Medicaid, home care, they should definitely file now, definitely file before October. Now, I'll do another program later on this year about what planning strategies should be implemented in preparation of October 1st. And then once we get past October 1st, I'll do another program, because this is a moving target and we're going to have to get more clarification from the New York State Department of Health as to how they're going to implement those rules. I'm not seeing any more questions in the queue. I'll just take a moment and tell you why I think my law firm is different, the Russo Law Group. We have 5 convenient office locations. We are open right now by appointment in Garden City, Islandia in Suffolk County, and Lido Beach. We're also licensed in multiple states, New York, as well as Florida, Massachusetts, and New Jersey. We have created co-counsel relationships throughout the country. So even if we're not licensed in a particular state, if you need help, we can be a resource. Call us and we can connect you to attorneys throughout the country. I think what we're really good at is listening to our clients who are in a crisis situation. They have a loved one that needs help. We're experienced, we can move quickly, and we'll do it with compassion. We're also very involved in the community. We're involved with our Teresa Foundation and Teresa's Fun Place on the grounds of CP Nassau in Roosevelt. We're involved with ADRC, the Alzheimer's Disease Resource Center, and a number of other not-for-profit organizations. For our clients, we've created a client maintenance program so that we can make sure we are being proactive for our clients and staying on top of your estate plan, making sure it's always accurate. And we also have discounted fees when other family members come to us of our clients who want our help. Our website can be a real resource to you and the community. All right, got one last question that just came in. And that question is from Frank. Why isn't there a change in the October date because of the COVID crisis? I don't have a good answer for you, Frank. My hope would be that they will make a change. You, along with everyone else who's in New York, it's an advocacy situation. Let your politicians know, your local representative know that this change in the law is really bad, and especially while we're down and out here with this crisis. And maybe we can get that date pushed off. Lastly, we would love to help you. We're open by appointment. We're also offering virtual appointments by video conference or telephone or home visits. Any which way we can help you. We've also created a resource page, a crisis resource page, and the link would be on our law firm website, COVID-19 crisis resource page. You can just, when you get the PowerPoint, which we'll post as quickly as we can, you can just click on that, or go to our homepage, and at the very top there's a red banner and click on it. I'm also doing a daily check-in. It's just 2-3 minutes if you want to hear what I have to say every morning before 10 o'clock. And we'll continue to do our Facebook Live events. And we've done several already during this crisis. And you can check them out also on our website COVID resource page. You go to bjrussolaw.com/COVID-19. Lastly, you can call us at 1-800-680-1717. My hope for you is that you're at home and you're safe, and I wish you the very best. Have a great day.